everyone. Let us see the case of Chintaman Rao versus the state of Madhya Pradesh. So the name of today's case is the Chintaman Rao versus the state of Madhya Pradesh. It was decided on 17th November 1950 and the citation of this case is 1950 Supreme Court. It was decided by 6-judge bench comprising Chief Justice Hiralal J. Kania, along with him Justice Fazil Ali, Justice Patanjali Shastri, Justice Meher Chand Mahajan, Justice B.K. Mukherjee and Justice S.R. Das was there in this case. So let us see what was involved in this case. In this case, there was a legislation and the name of that legislation is the Central Province and Bega Regulation of the Manufacture of BD's Agriculture Purposes Act of 1948. So what has happened? By invoking this particular legislation, a prohibition was imposed and that to be a complete ban was imposed on the manufacture of BDs, that is on the local cigarettes, and that to be it was made in the agricultural season, and the ground which was mentioned in the objective of this legislation was that as agricultural labours are needed for agriculture purposes, hence such ban was imposed. So the agricultural labourers are needed in the agriculture activities, hence for BD manufacturing such ban was imposed in the agriculture period. And what happened through this impose? A complete ban was put regarding the manufacture of the BDs. So there was one person, Chintaman Rao. He approached the Supreme Court of India. He was one of the person who was involved in the BD industry. He has challenged this act on the ground that by the imposition of such kind of prohibition, his fundamental right is being breached, and that to be the fundamental right of practicing any trade, occupation or business or profession as enshrined under Article 19, Clause 1, Subclause G of the Constitution of India has been violated. So he has claimed that his fundamental right, that to be as given under Article 19, Clause 1, Subclause G, which gives the freedom to all of the citizens of India to practice any profession, trade, occupation or business. So he claimed that by the imposition of such kind of prohibition, which according to him was neither reasonable nor it is in interest of the general public, was imposed, as none of the fundamental right is absolute, reasonable restrictions can be imposed. So the main issue behind the court was that whether such kind of imposition is being covered under the reasonable restrictions or not, because if something is being covered under reasonable restrictions, then that particular act or curtailment is perfectly justified. So the court has to examine whether that ban is under the coverage of reasonable restriction or not. So as Chintaman Rao claimed that that was not the reasonable ban, so the case was brought before the apex judiciary to check is it that prohibition is under the coverage of reasonable restriction as given under Article 19, Clause 6 of the Constitution. As none of the fundamental right is absolute, reasonable restrictions can be imposed on it. And if we see with respect to the Article 19, Clause 1, Subclause G, which talks about the freedom of practicing any profession, trade, occupation of business. So what can be the reasonable restriction with respect to it? That is being provided under Article 19, Clause 6. So court has to examine whether that kind of prohibition is under the reasonable restriction. That is the ground in the interest of general public as mentioned in this Clause 6 of Article 19. Is it the case? So the main legal provision which was involved in the case of Chintaman Rao versus the state of Madhya Pradesh is Article 19, Clause 1, Subclause G, which provides that all of the citizens of India have the fundamental right, and that to be with respect to practice any profession or to carry on any business, trade or occupation. But as none of the fundamental right is absolute, so reasonable restriction can be imposed. What is reasonable restriction with respect to the fundamental right of practicing any profession, business, trade or occupation? That is being mentioned under Article 19, Clause 6 of the Constitution of India. And as Article 19, Clause 1, Subclause G talks about the right to practice any profession or to carry on any trade, occupation or business, and this right is being given to all of the citizens of India. And what are the reasonable restrictions with respect to the right to freedom of practicing any trade, occupation or business? That is being provided under Article 19, Clause 6 of the Constitution of India, and that can be done, that reasonable restrictions can be imposed if it is in the interest of general public. So court has to examine in this particular case whether that ban on the manufacture of beedis in the agricultural season is being justified in the interest of general public. So here the court tries to balance between the two interests. On one side there is an individual interest, that is the interest of a human being, a particular person. That means if one side there is a issue of fundamental right of the person, and on another side there is the interest of the public. So court has tries to draw a balance between the private and the public right in this case, and court have decided that such kind of ban or prohibition, that is a blanket ban on a manufacture of beedis, is unconstitutional. The court has held that the restrictions which are being imposed by invoking the Central Provinces and Begar Regulation of the Manufacture of Beedis Act of 1948, the whole of the legislation is unconstitutional, because restriction must be reasonable. Because if any restriction is being imposed on any of the fundamental right, then that has to undergo the test of reasonableness. And how we determine what is reasonable in a particular case? So for that we have to see the objective behind that particular legislation. Every legislation is drafted, is enacted with certain objective which it seeks to achieve. So we have to see the intended objective of that particular legislation, and then we have to examine whether that ban, whether that restriction is in proportion to that intended object or not. If that is in excess to the intended objective, then it could not be the reasonable restriction. It means we have to see the objective behind the restriction, and then we have to see whether that restriction which was being invoked, which was being applied, whether it is proportionate to the objective of that particular legislation. If that is the case, it means that is reasonable restriction. But if that is in excess of the intended objective, it means that is unreasonable restriction. And if any restriction is unreasonable, then it is not justified and it cannot be put on a fundamental right of a person. Same was in this case. The court held that as the ban give a blanket ban on the manufacture, it prohibits the right to profession, the right to business, the right to trade of a person, and that to be in the agricultural season. And the ground which they have mentioned, that the labors are needed, is not the justified one. So the court held that the restrictions are unreasonable because it completely prohibits the trade during the agriculture season. If you have to put the ban, you could have restricted the number of hours if you are saying that labors are occupied in that profession and rather they are needed for agriculture activities. So complete ban could not be justified because it has prohibited the trade of the person. So hence it was held unconstitutional, and court has held that if a restriction is reasonable, then only that can be imposed on the fundamental right of the person. If that is an arbitrary restriction, it means that is unreasonable and that can never be imposed on a fundamental right of the person, which was in this particular case. And hence the court has tried to strike a balance between the public interest and the private interest, because on one side individual fundamental right of practicing any profession, carrying on any trade, occupation or business is involved. On the other side, through this legislation, they are claiming that the interest of general public is being protected, which was not the case, because one of the ground of imposing restriction on right to profession, trade or occupation is the ground of interest of general public. It means if something is in the interest of general public, then restriction can be imposed on one's fundamental right of practicing any profession, carrying on any trade, occupation or business, which was not in this case. And hence this court, the court, specifically the Supreme Court, have played a very crucial role in defining what is reasonable restriction, which has turned to be a milestone for the future cases to be taken into account while interpreting Article 19, Clause 1, Subclause G, which talks about the right of freedom of trade and occupation. Now, there is a practice question for you. One is in form of MCQ. Let us see what question you have to answer. You have to tell under which article of the Constitution a state can impose reasonable restriction, and with respect to what fundamental right? With respect to the freedom of trade or business. So you have to tell in the comment box that by invoking which article restrictions, and that to be the reasonable restrictions, can be imposed by the state on the freedom of trade or business. Is it option number A, Article 19, Clause 1, Subclause A, or is it option number A, which provides for Article 19, Clause 1, Subclause A, or option number B, which talks about Subclause G of Clause 1 of Article 19, or it is Article 19, Clause 6 as per option C, or it is Article 21 as per the option number D. So you have to tell reasonable restrictions are provided in which clause, and that to be with respect to the freedom of business or trade. And then there is one caution for mains. You have to tell that what are the judicial principles which governs the reasonable restrictions under Article 19 clause 1 subclause G, and you have to take the reference of Chintaman Rao versus the state of Madhya Pradesh. You have to write it down that on what principle judiciary used to decide that this is a reasonable restriction which can be imposed on a citizen's fundamental right of practicing any profession, trade, occupation or business. Thank you.